Now it's time for Blind Justice with Wade Brown. Wills.
Hi, today I'll be speaking with Tracy Spildy, a lawyer at Mazook Law based in Edmonton, Alberta, and she'll be telling us about a person's last will and testament. So first of all, can you please tell us a little bit about exactly what is a will?
A will is a legal document that allows the creator of the document to leave instructions in regards to who they wish to name as the person who they would like to represent them and administer their estate once they are deceased. As well, it gives them an opportunity to determine how they would like their personal property distributed, and in the event that they have minor children, it also allows them to name who they would like to be the guardians of those minor children.
Why do we need a will, or why might we want to make a will?
Every individual should have a will, and they require a will so that they can ensure that the person that is administering the estate is who they would like to administer their estate, and that the people who are in guardianship roles with any minor children are the people that they wish, and also that their property is distributed how they would like it to be distributed. In the event they didn't have a will, we do have statutes that determine who has authority to apply to be the administrator, and also how a person's property is distributed. But that may not be what the person would like to happen.
What's the difference between a grant of probate and a grant of administration?
A grant of probate is a grant issued by the court verifying the validity of the will and naming the personal representative as the person to administer the estate. A grant of administration is essentially the same authorization provided by the court, but it's to a person where there has not been a will left by the deceased.
What is an executor, and what do they do?
An executor is also known as a personal representative, and that is a person that you would name when you are drafting your will. That would be the person that would be the one to administer the estate. And their job is to apply for the grant of probate, to make sure that all of the estate debts are paid, to ensure that assets are gathered and given to the beneficiaries as the will intended.
What else might we want to consider when writing a will?
You want to consider what are your assets, what of those assets have named beneficiaries, what of those assets don't, how property is owned. So if you have real estate, is it owned as a joint tenancy with another person? Or do you own property with other people in another fashion? You also want to consider if you have minor children, who you would like to act as guardians for those children. If you have property in foreign jurisdictions or even in other provinces. And you probably also want to consider how do you want your estate divided when you pass.
Do we really need lawyers to draft a will?
No, there's no legal requirement to have a lawyer draft a will. That being said, lawyers do have the knowledge and the expertise to ensure that the formalities that are required when a will is drafted are met and followed. As well, they have experience in drafting wills that ensures that a person's instructions are what they intend, and that the will adequately lays out their instructions so that what they intend to happen is what actually happens.
Thanks, Tracy.
Thank you, Wade.